Minister, some of these amendments are technical, and some of them, you were saying, deal with the right of people to appeal. So, as others did the last time, because I wasn't sure if I had an opportunity to speak, I'll take this opportunity to make some points and really a last-minute appeal to you. You see, but where I will connect it to the amendments, I mean, I find it quite extraordinary that we have a whole series of forensic technical amendments and that the government can go to such trouble and such effort to make the bill technically operable. Lot of energy, lot of time to make a bill technically operable when it's morally obnoxious. And that has been made absolutely clear to the Minister by the people who are supposed to be at the centre of this bill, which are the survivors. And I have to say, at this point, I do find it quite extraordinary that the central issue that has been raised again and again and again throughout the passage of this bill, at the second stage, at the committee stage, and with thousands of emails from the survivors, that we still have not got a reasonable, if any, justification from the government as to why they have the arbitrary exclusion of 6 months.
Deputy, we're supposed to be addressing, you talk about these being technical.
Yeah.
In this report stage, it's the technical details of the amendments that we're supposed to address. We've had second stage debate. All these relevant points have been made.
Well, you just allowed them in the last grouping. So I think I deserve my opportunity.
It's our last chance to make any sort of
Yeah.
Go on.
So I find it absolutely extraordinary that you have managed to stay pretty stony-faced on all of this, and I'm sure you're aware of the feeling, the strength of feeling that is being expressed out there, and refuse to give the answer, to explain the exclusion, despite the last-minute and desperate appeals that have been made in this House, and more importantly from thousands of survivors, as to how you could possibly justify the 6-month exclusion or the refusal to fully acknowledge those boarded out, those who suffered discrimination on grounds of race, and you haven't given the explanation. And it's kind of, it defies belief that that is the case. And I suppose the only reason it can be is because there is no possible justification. There is no moral, rational, reasonable justification for the exclusion. And I wonder, I give you the last opportunity, Minister, to explain to the people who are watching, to explain to the people in the gallery how you came to this conclusion and how you are sticking to it, given all of the points that have been put to you by those who are survivors. And as you know, Minister, I was adopted in a mother-baby home, probably in 2, I don't know for how long. And that's genuine, I don't actually know for how long I was in a mother-baby home. But it's irrelevant. It's irrelevant how long you were in, because the primal wound is the separation of mother and child. That is it. And the impact of that on the child and on the mother is from the moment that happens, and that happens very, very early on, long before 6 months, and has lasting impacts. And those impacts are different for everybody. For some, they are, relatively livable with. Let's put it that way. For others, whether it was 1 week or 6 weeks or 6 months, the pain lasts forever. The trauma lasts forever. And for everybody, the impact lasts forever. A fundamental thing has happened out of your control, a decision made by the authorities in church and state to to alter your life in the most fundamental way, against your will. And 6 months just doesn't come into that. And I appeal to you, Minister, most importantly, just to, at this minute, pull back, as we appealed to you the last time round, and change this, so that nobody is excluded. Because, you know, even the most elementary understanding of human child psychological development understands that the formative moments of a child's development are those early days, hours, those early hours, days and weeks. So this makes no sense at any level. I would also take the opportunity to set out points that were made to me by a number of survivors this week, because you've put a lot of store on, well, people had access to their information. As others have said, they have the right. But it's also starting to come to light now that people aren't actually getting the information they thought they were going to get. That there's no consistency in how that information is being dished out. So in some cases, certain things are being redacted with black marker, and in other cases, they're being redacted by being whitened out. In some cases, people are getting information about, for example, their feeding schedule when they were in mother and baby homes, and medical records, and in other cases, they aren't getting those things. And people are beginning to wonder what's going on. But again, you know, this would matter somewhat less if there wasn't an attempt to exclude people. So there's a lack of consistency, excluding some, giving information to some, not giving information to others. That is compounding the wrong that has been done to children and mothers and those who went through the mother and baby institution. So I ask you, Minister, to respond at least, to give people an explanation, even though I don't think there is one, but to pull back at this last moment and listen to the people who matter in this debate.
Thank you, Councillor. In answer to the question in terms of the amendment made by Deputy Sherlock, the institutional payment scheme is based on, the access to the scheme is based on the evidence of a person's residence in one of the named institutions. That is primarily proved by the database that was created by the Commission of Investigation, the database that in 2020 this House voted to keep, to maintain and transfer to TUSLA. This database will be accessible by the independent office set up overseeing the payment scheme, and that will be the primary way in which residence within an institution can be proved. But we know, when it comes to some of the other points that were made earlier, we know that every institution either didn't maintain full records, or more importantly, particularly for some of the older institutions, those records don't exist anymore. The majority of records are were obtained by the Commission of Investigation and form part of its archive, which was transferred into my department again following its dissolution, but it doesn't maintain in every place. So in a situation where an applicant to this scheme wishes to access the scheme and we're not able to, using the database, prove residence, and that is the situation in which an affidavit will be applied. Is to recognise the scheme is designed to avoid affidavits where possible by simply allowing an official look at the records and see if the individual was in an institution at what time they were there for, but it recognises the reality that those records aren't in existence every time and offers an applicant another method by which they can access this particular scheme. In terms of the cost, you're right, there is a cost, obviously the cost there. It's important to note that Section 37 of the legislation deals with legal costs and records that legal costs for applicants will be covered within the scheme. So we won't be leaving applicants out of pocket in terms of the application they make under the scheme. In terms of the points on the birth information tracing legislation, and indeed the wider legislation, I think it's important to say both The other two major pieces of legislation that we've brought through, the Birth Information and Tracing Act and the Institutional Burials Act, both went through very extensive discussions, both in this House and in the Seanad. Both were subject to very many amendments through that process. The Birth Information and Tracing Act guarantees for the first time that legal right of access to a range of information: the birth certificate, birth information, health information, early life information. 6,900 people have now applied for their information under that scheme, and since it opened in October, already 2,000 of those have been 2,000 of those applications have been answered. I spoke throughout this legislation and said every piece of information that is within the records and that is covered by the Birth Information and Tracing Act will be provided to people. But I also said, Deputy, that not all information is there. And I was very upfront about that throughout the process. There may be institutions for whatever reason, whether it's a feeding schedule, whether it's really important piece of information. If the information is in the archive as held by either my department, by TUSLA, by the Adoption Authority of Ireland, the information will be provided to them. But there will be situations where that information doesn't exist.